Well, ladies and gentlemen, it seems that we have some brand new court documents regarding the Amber Heard and Johnny Depp trial. These were actually filed yesterday, and by the looks of things, they want to get started pretty quickly. And what we got a couple of attachments. There's obviously the brief of what they want to do. And it also shows that Amber Heard's team, they want to start doing depositions and everything else straight away from the 8th of September, which is after Labor Day weekend in the United States. So it's basically Tuesday they want to get this started. So we're going to jump straight into the video. So let's spin this around. Obviously we got Virginia in the Circuit Court of Fairfax County, as you can see, yesterday, 2:39 p.m. Defendants, AH, opposition to plaintiff, JD, motion for continuance. Plaintiff elected to bring this suit to Virginia and as such necessarily agreed to adhere to the rules of this court. The court clearly communicated to the parties they would be treated the same as all litigants appearing in this court. Yet plaintiff now requests this court to effectively stay these proceedings and delay plaintiff's deposition for 5 months while he travels to the UK for business. This is not good cause under the Fairfax practice, and granting the request would set a highly problematic precedent. On August the 7th, 2020, plaintiff was probably noticed for deposition lasting up to 5 days. Attachment 1. Plaintiff was invited to inform of any conflicts or alternative dates. Attachment 2. Counsel for defendant learned through Warner Brothers counsel, not through plaintiff, that plaintiff has no intention of appearing at his deposition. When parties to litigation face conflicts, it is incumbent upon them to find solutions such that the judicial schedule dates are prioritised for the effective administration of justice. Yet plaintiff made no effort whatsoever after counsel for defendant received no response to her questions about those efforts. Attachment 3 and 4. She proactively reached out to Warner Brothers counsel. Although plaintiff has been contacted in late June or July with the proposed filming dates, he did not alert them to the trial dates or the deposition. Instead, he waited until now and specially requested the letter attached to the motion for continuance. Plaintiff determined that rather than speak with his employer to work his film commitments around his deposition and trial, plaintiff is not filming throughout the entire 5 months. He had periods off. How do they know? And in spite of his being the plaintiff in this action, he asks this court to subsequently reschedule around his employment and the entire film schedule and production. It sounds like she's like, oh, I don't want him to do this, even though we've seen that this is what it was. We heard that obviously she was still going to be cast as Mera, and she was like, no, it's going to continue filming. We're going to have these dates no matter what. They're not going to give up on Johnny Depp saying that he wants to postpone it a bit so he can film. Plaintiff also claims the counterclaims justify continuing the trial. However, plaintiff provides no basis for why he cannot adequately prepare with 5 months between the filing of the counterclaims and trial, and refused to respond to defendants' questions on this issue. Attachment 3. With respect to count 1 of the counterclaim, plaintiff has indicated he is asserting the same claim against defendant. Count 2 is effectively the mirror of plaintiff's defamation claims, and count 3 is based on the conduct by plaintiff and his counsel, Mr. Waldman. If you're not following Adam Waldman, go on Twitter. This is his Twitter name. Which is a daily campaign to destroy the defendant's reputation and career through social media, the internet, and the press. So I'm going to stop by there for a moment. So obviously, the counterclaim is for $100 million, which is just absurd because there's no way does she deserve that. If she was going to do a proper counterclaim and countersue, it should be for the same, not double for what's going on. She doesn't deserve it. That's hands down. But I do like how she is still bringing in Adam Waldman because he's letting everyone know the truth. That is all he's doing. When you over here in the UK, when you got the media, so you got the Daily Mail, the Sun, Daily Mirror, the PO, Sunday People, the People, Daily Star, all these newspapers, they've all ran the same story. And she's saying, oh, it's to get rid of me. Actually, no, because these are smear campaigns by these papers to prove that Amber Heard is a goody-goody. she's done this, she's doing this, she's amazing at this. But we've seen all these headlines are literally having a go at Johnny Depp. You know, and saying, oh, she feels attacked because he keeps doing this. No, that's not what's going on. Getting back to it. Plaintiffs should be well prepared to defend against these actions, which need to stop, to only a trial will effectively end this campaign of orchestrated by the plaintiff. It's not that, we all know it's not, because she's even said that everyone who has signed the petition, everyone who is against her, are Russian bots. We're not Russian, I'm Welsh. I'm the furthest you can get from being a Russian. Prejudice is not a factor for the court in determining whether to grant a continuance, but if it were, defendant will be significantly prejudiced. No, she wouldn't. She has expanded a significant amount of legal fees and costs defending this litigation, which will only increase exponentially with a 5-month hiatus and continuance. Defendant's career has virtually halted, with the exception of Aquaman 2. There we go. Which she was told months ago would be filming in February 2021. Warner Bros. Counsel said they do not know when Aquaman 2 will begin filming, but it will be sometime in spring of 2021, which is also a basis for denying the continuance. If filming of plaintiff's movie is good cause, then this case could be continued again. If defendant's filming begins through restoration, and so on, establishing a slippery slope precedent. This court recognised the importance of strict adherence to trial schedules in the practice manual, and it goes on to saying about the judges of the Fairfax County Circuit Court believe that the maintenance of strict calendar control leads to more expeditious and efficient administration of justice. They're literally now saying, well, you can't let him do this, because if you let him do this, you're going against this. It's like, come on. Don't be that naive. But again, no, personally, I really do think she's trying to get out of it as quick as she can. Oh, just quick, let's just do this now so we can do it. And if we say we got the dates, we want to do this, we want to deposition this person on these dates here, and here, they have to let us go. That's what it seems to be for me at this moment in time. We do have quite a few pages to go through still. I'm not going to go through all the attachments, only a key few. Section F 1.0, this case has already been continued twice because of this, which is good cause. Plaintiff's motion should be denied and plaintiff should be ordered to appear at his deposition as noticed, subject to reasonable protocols. So what basically this entire thing is, her and her counsel do not want this to be just put to one side, delayed for a couple of months while he goes filming. Because she's like, well, no, if he's going to do that, I want to do it as well. And it'd be interesting to see if this does go ahead, in January, that if it does get delayed or whatever, only for a couple of days, if she's going to be like, well, I'm filming in February, I want a continuance. I want this to be delayed. Let's see how that goes. Personally, if I was Johnny Depp, I just want to get this over and done with as quick as I can. But obviously, when you sign contracts are there so you don't break them. So we've got the Statement of Key Facts Summary of Issues. On May the 18th, 2020, plaintiff participated in setting the January the 11th trial date, estimated to last 3 weeks. On August 7th, defendant noticed plaintiff's deposition for up to a week in Virginia beginning October 5th, to which defendant has not objected to places or dates, has provided no alternative dates, or objected to the suggested protocol. Attachments 1 and 2, plaintiff did not meet and confer before filing this motion. Well, he hasn't got to. He hasn't got to meet with you and say, oh, I want to delay this, so if we do it, it'll be fine. No. If he wants to delay it, that's his and his counsel's choice. They haven't got to ask you for permission. Attachment 3 and 4, he refused to respond to defendant's questions or provide any information on when plaintiff first learned of the filming schedule, plaintiff's efforts to schedule around his deposition and trial, and plaintiff's time off during the filming. Attachments 3 and 4, after plaintiff refused to respond to these reasonable questions, defendant issued expedited discovery requests. 6 and 7, asking for the responses to be provided to defendant by September 1st, otherwise due September 10th. Plaintiff did not respond to the email request for information for a meet and confer, did not expedite any responses, and has not responded as of the filing of this opposition 2 weeks later. With no information provided by plaintiff, counsel for defendant reached out to Warner Brothers Number 8, and learned that plaintiff would have been contacted in late June or July to discuss the rescheduling of the filming, and that, contrary to plaintiff's representation, he learned well before the August 19th letter. In fact, he requested the letter from Warner Brothers. It was not sent in the ordinary course of business, nor was this how or when plaintiff learned of the filming schedule. And it just goes on, basically, it does just go over the same question each and every time. Well, Warner Brothers said this. Warner Brothers said that. Mr. Waldman's doing this. Mr. Waldman's saying that online. And it's really funny to see. So we're going to go into the attachments now. So we've got attachment 1. So we got that there. Notice of deposition by video. Please take notice that the defendant, Amber Laura Heard, by counsel, will take the videotape deposition upon oral examination of Johnny Depp beginning at 9:30 a.m. on October 5th and each day at 9:30 through October 9th. So we got a couple of days there. To be continued further if necessary and not completed. It'll be held at certain offices. Then you have all this there. Everyone's gone through it and signed it. But then you got attachment 2, which is an email from Elaine Bredhoft. So, Ben and Camille. Given the fast impending trial date and the deadlines associated with the trial date, we would like to take a significant portion of the depositions during the months of September and October, beginning immediately after the Labor Day weekend. Many of these depositions will be taken in California. We recognise in light of this that we will need to cooperate fully, respect the legitimate concerns of deponents and counsel, and develop protocols to handle these depositions to maximise fairness and protections. So he said about October 5th when they want to deposition Johnny Depp. But then it goes down by here where we have the list. So, with respect to the other depositions, we would like to schedule the following during the months of September, beginning after September 8th. I am suggesting dates and would like you to let me know if you and your team have any conflicts with these. I plan to issue the subpoenas for those requiring subpoenas next week, so I'd appreciate you letting me know your conflicts as soon as possible. So then we got September 8th, Brandon Patterson, corporate designee of ECB, East Columbia Building. September the 9th, 2020, Sean Bett. I understand you have agreed to accept service for him, and assuming you have produced the documents for his subpoena in sufficient time. Then September 10th, you got Stephen Deuters, same as above. September the 11th, you have Chris Dembrowski, assuming she has complied fully with the subpoenas. Then you got September 14th, you got the LAPD one. Then you got Melissa, Officer Tyler. So you got the 2 police officers then on September 15th. The ones who went to her house and they're like, yeah, there's no marks on you, love. We're not taking him away. First, he's not here. But again, no, that is the law in California and Los Angeles area. If there's some kind of row going on, they automatically have to take the suspect, or whatever you want to call them, away. But it never happened. But then you got Ben King, Robin Baum, Malcolm Connolly, Nathan Holmes. Then you got all these people going on. Basically, people who worked for him and the police officers in the building, ex-people. So you got all of these, and they want to be done between September 8th and September 30th. And that's what they want. Which, again, to be honest with you, I'd be like, right, okay, that's fair enough. If you want to get them out of the way with, you can do it. And the last one we're going to take a look at is actually a letter from Warner Brothers. And this is what we got. So, Fantastic Beasts 3, Johnny, actor, Dear Edward. The theatrical motion picture, presently entitled Fantastic Beasts 3, the picture, is being produced by this company. Pursuant to the agreements between company and LRD Productions, FSO, Johnny Depp, artist, is currently scheduled to render services on the picture in London on an exclusive basis commencing in early October 2020 and running through and including the middle of February 2021. Of course, as is normal in film production, these dates are subject to production extinguishes and further scheduling changes. And as you can see, that was actually sent on August the 19th. So, straight away with them saying that he knew in June, July about all of this, well actually, this letter states otherwise. This letter states August 19th, and then it was only a couple of days later when he filed for it to be delayed. So, I think, with them actually attaching this to there, it's like, what are you doing? You've added a bit of evidence for them. But again, no, this is what these people try and do. They try and say, well, look, he knew here. It's August the 19th. A couple of days later is when he filed for it to be delayed. So what I will do, though, I will leave a link below for everyone who wants to read the attachments, because there's quite a few, up to page 10 is just the actual filing of what she wants to do, even though it's basically page after page of the same shit. And then these are the emails, these are the people we want, these are the subpoenas. And before we finish this video, we still haven't received the judge's verdict for the case here in the UK. Fingers crossed now we get it within the next couple of days. Hopefully next week when it comes out, he'll be like, right, okay, I'm doing this. So fingers crossed for that. If you are new to the channel, please like and subscribe. Hit that notification bell for future updates, and I'll see each and every one of you soon.